Appeal Number 79, Gevorkyan versus Judelson. Counsel?
Good afternoon, Your Honor. May it please the Court, I ask for 2 minutes to be held for rebuttal.
Yes, you may.
Thank you. In all insurance transactions, premiums follow risk. Premiums are dependent upon risk. No premium is earned without risk. Insurance is the ancient mechanism by which risk is calculated.
Is risk mentioned anywhere in any of the statutes that apply to the bail process?
It is not.
Okay.
It's not.
Counsel, what does it mean to give bail bond?
To give bail bond, as analyzed by the Attorney General's brief, is to pay the money or get the bond itself, money in terms of cash bail, or the bond itself accepted by the court, and that the person is released as a result of that acceptance by the court.
And what legal authority do you derive that answer from?
Well, it seems to be inherent in Insurance Law 6804B, in which it said that the bond is proposed to the court by the surety.
So what is posting bond?
Posting bond is a term which apparently has no real definition. It's taken to mean the bringing of the bond to the clerk in the part where the case is to be heard, which then sets up a situation where there is either a sufficiency hearing to be scheduled, or the bond is accepted and the person is released upon bail, having given bail, and now being released having had the bail accepted by the court.
So just to clarify, so posting bond means to actually turn over funds to the court?
That's
or
our
not?
position. I'm sorry. That's our position in the absence of strict statutory language of what posting means. Posting appears to be a conglomerate of several acts. Having the bond prepared, signed, that is executed in that sense, brought to the clerk, having a cut form generated so that the person is delivered by the corrections department to the courthouse, or the sheriff, depending on where you are, and then having the court review the bond, and if there's to be a bond sufficiency hearing, the hearing is held, the court grants or denies the bond, and the person is
So there's no definition,
No.
right? Is this just the practice? This is what is understood in the industry, if you will?
It appears to be understood in the industry, but there seems also to be a wide discrepancy of what that understanding is.
Counsel, could you contract this away? So if this contract had provided, this money is due and payable, and it was clear at the stage where it was got to in this case, could you do that? Could you contract to have this money owed?
I believe that there's a contract in the record which was proffered by the Bronx Defender's brief that has that particular provision in it. It says that if a bond is brought to the court and a sufficiency hearing is held, and the sufficiency hearing is bad for the accused, then they will not get their money back.
Right, so if you can do that, and we have an interpretation from the district court here that this was ambiguous as to that point, this contract, and they had a hearing, and they interpreted it as that's what you meant, what provision overrides that?
Okay. I don't think that I agree with the thought that you can do that. I think you can write up a contract that says that. But
So the contract that's in the record you mentioned would be void?
I believe so. And it would be void for the reason that the statute requires that bail be given, and that includes the acceptance of the bail, the providing of the bail, and the release of the prisoner.
This type of insurance policy has some differences from other types of insurance policies. And one of them, to me, is that an automobile insurance policy or a homeowner's insurance policy, or the types of policies that most people are used to dealing with, have a fixed period of coverage, maybe a year, maybe 6 months, whatever it is. And so that if a partial premium refund is due, generally it's prorated in terms of that time. If under the law here, I assume it's your position that, that a partial refund would be due if the defendant was returned to custody sometime before the case was over, how would you determine how much of a refund was due?
It's a very good question, and one that's not been considered by any court or any case that we're aware of. Article 5th of the contract in this case says exactly that, that if the bail bondsman decides to turn the person back in, he has to repay the unearned premium. I believe...
So to piggyback on Judge Garcia's question, if you're saying that you can't contract away the right completely, but are you saying you can contract to how the refund would be calculated?
I suppose you could, certainly not in this contract. It wasn't calculated, nor was any calculation set forth, not even a theory of how to calculate.
Okay.
But I believe there must be a wide-ranging body of law in figuring out exactly how an unearned premium is calculated. I'm sure that in the case world where insurance companies have to account to the government for their reserves and for their unearned premium reserves, they have to say, we calculate that we need to give back X under an accounting or accrual sort of theory. I'm sure there's a wide body of law that would answer that question. I'm not aware of it, but there has to be a method by which it can be calculated.
But that's not an issue in this case.
No, it's not.
A defendant relies on a 2010 opinion from Department of Financial Services. You're familiar with that in the record?
Yes, sir.
And that opinion seems to be in conflict with the position that DFS took as an amicus, in their amicus brief before us. Do you want to comment on that at all?
Yes, sir. I don't believe it's in conflict at all.
Okay.
And I don't believe it's in conflict for the reason that it deals with the intra-bail bond commercial relationship between bail bondsmen and their companies. It doesn't deal with...
As opposed to between the carrier, and between the parties in this action. So would they, so then should the carrier have been brought in directly here as opposed to the bondsman?
I don't believe that that ever became an issue, and
I was curious why the carrier wasn't brought in, I have to say.
It appeared from the paperwork at the time that the bail bond insurance company had denied that there was a bail bond written. I believe that in the record there are 2 letters from the insurance company. There's one that says, no, it has nothing to do with us, we didn't write it. We relied
International
upon it.
Fidelity?
I'm sorry?
International Fidelity?
Yes, sir.
Yeah, okay.
And then later on, they wrote another letter that said, oh, yeah, by the way, we're wrong. But we relied upon the first letter in our assumption or our analysis that they were not part of the case and that the bail bondsman had retained the entire premium himself. And going back to your first question...
But that wasn't the case. In point of fact, they were, and they were never brought in, but no one ever challenged it on that basis.
No one ever challenged it. And to go back to your first question, Judge Fahey, the DFS also had goings-on with Mr. Jabbar, the employee of Judelson, in which they reached an agreement that this sort of thing wouldn't take place. And apparently, that agreement, it's a footnote in the Attorney General's brief, that agreement that Jabbar signed just before he testified in this case was not mentioned at the trial.
I see.
Counsel, when the bond was posted, did Mr. Judelson complete his work?
Well, if you could tell me what you mean by posted, I could answer the question.
Well, when he made his final submission to the court.
Well, okay, so he took the bond over to Supreme Court in Kings County. He went to a clerk there. He gave them the bond. The clerk then generated the cut slip, which is in the record. If that's the point that you're talking about, no. And in fact, his job is never done until the case is terminated and the bail is exonerated. Under my theory, he always owes an unearned premium until the bail is exonerated. The person is, as you know from your own experiences as a district attorney, the end of the case means that the action is terminated, and the court will generally then say the person is sentenced or he's freed, bail is exonerated. That's when the case is over, and that's when the unearned premium should be calculated at zero, and that's when his work is over, I think.
And at the point at which the judge determines at the bail source hearing that the bail is insufficient,
Yes.
is his work done?
Well, his work is done to the extent that he no longer has to do any more work, but it is our understanding and theory that he has not earned a fee either. It's the same as the attorney who's handling a contingent case and loses, jury verdict is entered.
So it's your position, no compensation?
That's correct.
Thank you, counsel.
Thank you.
Counsel?
May it please the court, Eric Del Pozo for the State Department of Financial Services. The bail bond premium in this case must be refunded because the bail bond, which is an insurance contract, never took effect. Judge Garcia, you asked whether the parties can contract around this principle. They can't. We get that from Insurance Law 6804B2.
And you're in charge of enforcing those rules, right?
DFS is, that's right.
Have you brought any enforcement actions in this area?
DFS is not on this particular issue. It first received complaints that unearned bail bond premiums were being retained last year, was considering taking regulatory action. This court accepted the certified question. So the question, this court squarely confronts the question, and DFS is here as amicus to explain its
So
statutory
prior
interpretation.
to last year, there had been no complaints about unearned bail premiums being retained?
DFS has not advised me that they'd received any complaints prior to last year. The Insurance Law 6804A, the parties agree, provides the exclusive compensation for a bail bond surety in the bail bond process, and that compensation arises for giving a bail bond. 6804B2 is a sweeping prohibition on any other fee or charge for obtaining a bondsman, obtaining a bail bond, anything else in the process. As we've argued in our brief, giving bail bond means securing the defendant's release.
But it doesn't say that in the statute.
It doesn't, Judge Garcia, but all signs of legislative intent point in that direction.
So what is the strongest sign of legislative intent pointing in that direction?
The use of the word premium in the statute would be the strongest sign. And premium is a term of art in insurance. It means consideration for an insurable risk. When there's no insurable risk, as in this case, for a bail bond, that risk only
Premium's
arises.
in the statute. I mean, you have to look at the legislative history for that, right?
I'm sorry, Judge Garcia?
Premium is in the statute, so why would we need to look at the legislative history for that?
It's not legislative history so much as it is the well-developed body of New York law, predating the statute's passage, unbroken up until today. If the legislature had meant to do violence to this well-settled principle of insurance law, which appellants have argued, as have we.
This really isn't, it's a different provision, right? It's the bail provision here. And I guess your view would be in any case where there was a contract which provided for any insurance contract, bail, whatever it might be, where two sophisticated business partners contracted for a premium to be earned at a certain point before risk attached, it would be void.
That is DFS's view, but this court need not go that far because we're dealing with a specific set of laws in a specific industry.
The specific set of laws you're pointing to don't say that, so we would have to make it as a matter of insurance law, right?
But they do say that when you look at all of the markers of intent. There is the word premium. There's also the plain meaning of giving bail, which we've argued. We've pointed to dictionary definitions, other sorts of laws, the CPL extradition provision. All of those connote the defendant's release. There's 6801, which makes giving bail synonymous with executing bail. And if you look at 6803, this is firm contextual support. That's the source hearing provision. And it says that at the beginning of the source hearing, a surety is just a proposed bondsman or proposing to execute a bond. So all of these markers of legislative intent together compel the statutory reading that
What if
DFS
there was
advances.
a contract that said you earn this much of the premium up through the sufficiency hearing? Let's say 20%. Would that be okay?
It wouldn't under the statute. It wouldn't be a premium either. A premium depends for its existence on an insurable risk. And for
So
a bail
could you
bond, that,
define it as a fee that equals 20% of the premium as a fee for assembling the package for the sufficiency hearing, or you just never get paid for, it's always a contingency contract?
it's going to be a form of contingency contract. The paperwork in itself is not going to be compensable regardless of what the parties call it. Now,
Well, would it be a
the reason-
percentage of the premium or a percentage of the amount that the court had originally set, which it may not be satisfied, can indeed be put forward based on the inquiry, based on the hearing?
I'm sorry.
I mean, your position is without risk, there is no such thing as a premium. So
That's right.
then you can't have a percentage of a premium without risk, correct?
That's right. Now,
Okay, so what would be the other way to calculate the percentage, just on some amount that they come up with?
No, the percentages here are in the statute, the maximum percentages.
No, I'm sorry, I'm not being clear. Let's say we agree that premium means risk. We agree that there's no risk if the person is not actually released. Okay, so then how do they get paid for any work they do? They would charge a fee? Or
It
they
would-
could negotiate an amount?
If the court accepts the bail bond and the bail bond is given within the meaning of the statute, the paperwork and the effort is folded in to the amount of the premium. We're in a situation here where the court has rejected the bail.
But that's
the
what I
bail
mean.
bond.
In that scenario, what would a bondsperson or the company be able to charge for whatever it has done up to that point?
Whatever they were able to charge Judge Rivera, the agent would have to get that compensation from the insurer, not the criminal defendant and the criminal
Isn't the right
defendant's
answer, they
families.
can't charge?
They can't charge the criminal defendant, that's right,
Right,
Judge Fahey, and this is exactly the point of DFS's 2010 council opinion. The bail bond agent can protect himself by contracting with the insurer, the surety underwriting the bond, so that if a situation like this arises where you've put in a lot of work and you want to be compensated for it.
Right, but they
you
can't
have
charge
that
the
option.
defendant. They can bring their claim to an insurance carrier and have a deal with them directly, but they can't charge the defendant.
That's right, Judge Fahey, and I see that my time is up, but I'd like to spend a minute or two, if I could, talking about the equities of this case.
We'll allow you another minute.
Thank you. There is no support whatsoever for the competing statutory view that the premium is payable on posting. There is a definition of posting. It's in the criminal procedure law, 518. It's submitting the bond documents to the court. Now, there may be a source hearing, there may not be, but the bond is not approved simply on posting. The court has to take another step. That a rule that the premium are payable on posting would invite untoward consequences and frankly, all sorts of abuse. The bond could be rejected for lots of reasons that have nothing to do with the blame of the criminal defendant or his supporters or the alleged taint of the funds. The collateral could be insufficient, for example, or the surety could be unreliable. And in that case, under Mr. Judelson's view, the premium would still be payable. That would incentivize submitting bonds that would fail a source hearing, and that would be a perverse result. Even if the funds are tainted, there's no good reason to let the bail bond agent keep those funds. The defendant never should have had them in the first place. They could be criminal restitution, go to the
In the
state.
equity sense, there were two companies, as I understand it, that refused to even go through the process of trying to put a package together. Isn't it equitable that in order to even get a company to pay, to put in the effort to put this bond forward, assuming this was a very high risk always, and that's what they contracted for? To get one company, I mean, otherwise, they had already been 0 for 2, no company would have done this. But your rule would be they can never do that. So the bail bondsman would be, why would I put a package together which has potentially a chance of failing here because it's a high-risk case? So where are the equities in that?
Well, there's one set of bail bonds that are going to be categorically discouraged by a rule that premium arises on giving bail bond when the risk arises, and that is bonds with no reasonable hope of success.
Wouldn't the rule be you can contract that right?
That would be in a statutory vacuum, in a world where this court, both in 1938 and 1977, hadn't already reaffirmed the principle that premium follows risk. So if we were dealing totally on a blank slate, of course, the parties could.
Would make it this, and it attaches then, but why couldn't we make a rule that says it attaches when you contract for it to attach? And in this case, Judge Berman decided it was ambiguous, and you had contracted, the parties had contracted for it to attach at this stage.
Well,
Why wouldn't that be the rule?
In this case, insurance law 6804B2 would bar that rule. There's another provision of the insurance law which is 2314, that states that parties can't contract around permissible or approved rates. And if this court were going to reach any contractual holding, it should be that there's an implied non-waivable term in every insurance contract that no premium is due until a risk of financial loss arises. If there are no other questions, I thank you.
Thank you, counsel. Counsel?
Thank you, Your Honor. My name is Jonathan Svetke. I represent Ira Judelson, and I'd like to start with the big picture here, because I think it's critical for Your Honor's decision
What
here.
did the bondman, do here to earn the particular premium that's in dispute?
Well, Ira
The
Judelson,
actual steps that the person took.
the actual steps involved meetings with the client's sureties, the client's obligers. There's a meeting that took place in New Jersey that's documented in the record. Ira Judelson submitted testimony by way of affidavit indicating that there were hundreds of hours, not only by himself, but by his staff, in preparing the paperwork for the bond. The undertaking of the bond requires a list of all of the sureties, all of the people who are going to be obligers on the bond. They have to sign off on paperwork. All of this has to be prepared. There were additional meetings. The meeting in New Jersey took place over 6 hours. There were steps to obviously bring the undertaking to the court. The judge signed the undertaking.
What percentage of these, do you have a general sense of how many of these are refused or
No,
by the court?
and that is the critical question. That's the big picture here, because if you decide that the certified question, in the negative, that the bail bondsman cannot retain the premium, even if the surety fails, or even if he posts in a situation where there is a parole hold, even if there's a situation he posts and there's an INS hold, if the requirement is that the defendant be released, then what you're setting up here is a situation where there will be less bonds issued, there will be less bondsmen, there will be more people in jail.
But why is that? Because you say there's no risk to these. This is unlike any other insurance policy. There's no risk because we don't issue it unless we have enough security. Well, if that's the case, then, let's say 1 out of 10 you lose, you have to give back the money because the bond isn't accepted. But in the 9 other ones, you're collecting these fees that there's no risk you're going to lose, because even if the defendant absconds, you have your security. So if that is all true, isn't it still worth your while to try, because you're still going to get 9 out of 10 of those fees and you have no risk?
Well, the problem is we're discussing it in a vacuum. We don't know that information. We don't know whether it's 1 out of 10 or 9 out of 10.
But let's assume that's true. Let's assume it's 3 out of 10, that doesn't make it.
Then you have a bail bondsman in a situation, and specifically in this one, you have the big picture and the small picture, but in the big picture, you have bail bondsmen who are confronted with a situation where they're going to have to go through work expense to post a bond.
But
and a
what I'm
particular
saying is, isn't that a balance? Don't they have to determine whether they can make more money? How much effort really goes into this compared with how much money they can earn on the ones that go through?
And I can tell you, based on my information, that a decision that prohibits them from taking the bail bond in that situation would reduce the number of bails issued. I'm talking about that from just, I happened to speak with a bail bondsman before I came up here. But I think it illustrates the point that in order for you to determine whether or not the statute as written prohibits a bail bondsman from keeping this fee, there has to be some sort of investigation, has to be some sort of information gathering to find exactly what's going on with the bail bond
Why isn't
proceeding.
DFS right in their approach, which is to ensure you're properly compensated, apart from the premiums? If there's no risk, no premium. But if you want to ensure that you're getting some compensation, that's what you arrange with the business entity. But you can't turn to the defendant or whoever other people on behalf of the defendant who approach the bailsman, the
Well,
bondman.
it's the same problem for the business entity. The business entity
Well, there's
is-
money to be made. You cannot deny that. Otherwise, you wouldn't be in it anyway.
Right, but they're in it because under the current statute, under the current
It's not out of
circumstance-
goodwill, it's to make money.
It's to make money, and
So the question is
it's-
just
it's
who's
a-
going to pay this particular portion? If the money is to be made, they'll pay it because they're going to get more money out of it.
I don't think you can determine that on this record without additional information. There is a risk-reward analysis that has to be made by any business.
But
Let's
your,
assume you're
back to
right,
your,
and that they stop issuing these bonds because they don't like the risk. I mean, can't we assume that the legislature would then ask, because the legislature obviously wants this to be available, and they would act to change the rules?
Well, I would argue it in the reverse. I would think that if it's become such a problem, that the statute in the first instance does not restrict the bail bondsman from retaining the premium under the circumstances in this
If
case.
you disassociate the risk from the price, from the premium, why aren't you setting the wrong price? Right, don't we want the risk to follow the premium so that the price for any particular person's bond measures that risk accurately?
I think that's one element of it, but I think because you have a unique product here, which involves not only the fee for the assuming some sort of risk involved in ensuring the defendant's return to court, you also have attendant circumstances involving the work that's required in order to post the bond.
Why don't you
So
build that into the price? That's part of what you're paying for.
I think that's what the statute contemplates, and that's why, that's part of why the statute does not allow for any charges for fees or services, expenses. It's a one-set fee that not only measures the risk involved in the bond, but also measures the amount of work and the amount of expenses that
But
the bail
that's a
bondsman
type
has
of
to-
risk as well.
But absolutely,
that
yes.
just seems like to follow up on Judge Wilson's question, it seems just like part of doing business. It's the cost of doing business and a risk. If you write 100 a year, maybe 3, you'll end up getting nothing on.
Yes, but they've been operating this business for 20 years, the bail bondsman's, under the current statute, which has been interpreted, and which they've been operating under, as allowing for them to keep the premium, even if the surety fails, even in a situation where you have somebody who's going to post for somebody who has a parole hold or an
Again,
INS hold. You can't.
Isn't that,
I'm
yes,
sorry.
but isn't that resolved, again, as DFS suggests, you're just shifting who's going to pay, and it's not going to be the defendant. You're just shifting the payment. The
But
money
if
will be
you-
there.
But if you're shifting the payment to the insurance company itself, as opposed to the bondsman,
They're certainly better healed than the defendant.
yes, but it's certainly, if they're going to make a benefit risk assessment as to whether or not it's worth going forward, they're not going to do it.
Well, let me
You know,
ask this.
I'm sorry, go ahead.
Suppose we disagree with you, and suppose we agree with your opponent. What effect does that have financially on the cost of bail?
Well,
Will it have
I-
any effect? Because they haven't said in city court for a few years, I have to say I saw very few bail sufficiency hearings. They were relatively rare, and usually came up in large drug cases like that, but they seem to be very, very rare. And so this seems to me to be, in point of fact, from an economic point of view, I saw nothing in the record that would make me think that this would have a real effect on the industry or your ability to write.
Well, 2 points on that. One is, this is New York, was a New York City bail bonds, and the numbers, I don't know the numbers. There's nothing
Neither
in
do
the
I.
record
I'm asking you because I don't know.
Yeah, I don't know the numbers. And that's why, again, I think that this is the type of issue that has to be kicked back to the legislature.
But counsel, usually, it would seem if you have something like this come down, and it's not going to be the insurance company, it's going to be a bail bondsman, in an ordinary world in insurance, it would be passed along to the people who pay the premiums. But as I understand it, your premiums are capped here, right? So it's not going to be a question of passing along a higher cost to the consumer here. It's going to be a question of writing or not writing in certain cases, right?
That's 100% correct. Yes, Judge. And that is the point I'm trying to make in terms of
Well,
the
sure,
big
everything's capped, but so over $10,000, it's 6%, right? Is that the cap we're talking about?
I believe so, yes.
Yeah, all right.
I mean, you're talking about.
So it's the evaluation of the risk, and that's the business decision that the carrier makes. Would you say that's correct?
Yes, in
All right,
terms,
so if it's an evaluation of the risk, then therefore, in that calculation, that's a pure business calculation. What's my
right.
risk?
And now they're going to have to calculate, assuming the court rules in favor of appellants, they're now going to have to calculate. I see my time is up, but I do have, I want to finish on this point, and if I could add something for the court as well.
You can, but I have a question for you. Who received the premium here?
The premium was received by Ira Judelson. And if the premium is, I'm sorry, Your Honor, I forgot the.
That's okay, that's all right,
Okay.
that's all right.
The
Make your,
point I
you
just
go
wanted
ahead and make your
The
point.
final point I wanted to make was that when you go back to 1997, when this legislation was first enacted here, you had input from the Department of Financial Services, New York State Department of Insurance at that time. There's a two-page letter there. There's nothing about risk following premium in that. There was the decision that was mentioned here, which was interpreted by a United States District Court judge to lending some credence or some support for my client's position here that the premium is earned at posting. You had evidence in the record that my client was contacted by two attorneys who were seeking to get the money back. He gave them the number for the New York State Department of Insurance. They called there. They were told that once the bond is posted, that the bondsman is entitled to retain the premium. Mr. Judelson himself called the New York State Department of Insurance all the time while they were asking for the premium back, was told that he could retain the premium. And he also spoke with the Attorney General's office, the prosecutors who prosecuted the case and were in charge of overseeing the surety hearing. What I'm talking about here is there's another element of reliance that Mr. Judelson and his colleagues in the bail, who issue bail bonds, relied on this history. And to now penalize him for that reliance, I think would be unfair, and that's the small picture of this case.
Thank you, counsel. Counsel?
Thank you, Your Honor. In a far greater industry, far more attorneys are willing to take cases on contingencies. And you don't hear them say, well, I had to investigate and I should get a portion of the case even though I lost the verdict. It's a cost of doing business, and it's well understood by contingent fee attorneys that they're not going to win every case. They're going to win some, and they, in the same sense that the bail bondsmen have, are given a guild entry. Bail bondsmen who are licensed are able to sell a product at a set fee, which apparently is quite a bit of money, $120,000.
But isn't a contingency, is a contract, to me, the analogy then would be, I'm a lawyer, I sign up for an hourly rate, and at the end of the day, a court comes in and tells me, no, actually, you can only do this on a contingency basis, and you lost.
No, sir, I don't think so.
Because there's no contract here that says this is a contingency. In fact, the contract has been interpreted to say it means what your opponent says it means. So there has to be some law coming down from above on top of that contract that says what you agreed to isn't effective.
And I think there is, Your Honor. I think
But that's where I lose your contingency
6804
analysis, because there's no law in the legal profession that says every time I take a case, a civil case, I have to do it on a contingency basis.
No, but there are appellate division rules in each of the 4 departments that say if you take it on a contingency, your fee is capped, the same as 6804 caps the fee for the bail bondsman. And the bail bondsman, who knows that the only fee he's going to get is set by statute, knows he is
Well,
not...
then it's more analogous to I take on a case and I have a cap. You know, you can bill an hourly rate up to $500,000, and then you turn it into a contingency fee. Say, yeah, but you lost.
I disagree with that analysis, Judge. I think that this is the same as an attorney who takes on a case for 1/3, because that's what the appellate division says you can get for a personal injury, wrongful death, condemnation case.
But
And they know that when they start.
Well, is your point going to, that this will not be the end of the industry? This
will
won't
not-
dry up the availability?
It shall not
bail
dry up the availability, because on the cases they take, they can get as much security as they want before they agree to write the bond. If it's a $2 million bond, they can get $10 million worth of security from the criminal defendant before they take it to the court. They are totally covered for any eventuality at all. I also wonder why bail bondsmen are writing bonds for people who cannot leave jail. We've heard about parole holds, INS holds. We've heard about extradition holds. It's like going into court and offering ROR to a defendant who can't get out of jail. Not only is it worthless, but they lose their good time credit while they're sitting in jail. Why are they writing bonds for people who can't leave? Is there any reason for that at all?
Thank you, counsel.
Thank you.